All right, I'm going to agree to set aside the order adopting the referee's recommendation because I do believe that plaintiff's counsel had an answer ready prior to or had an objection ready prior to the expiration of the time period, but there was an issue with overnight mail, which he has documented in his motion, that appears to me to be while he was skating very close to the edge as far as the time limit, he did take action, substantial action within the time limit that normally would have gotten the objection to the court within the normal time period. It was but for the court's efficiency, where I entered the order on the first day that it was possible to enter that order. In most courts, and quite frankly in this court, normally it would have taken a couple of days and the documentation would have been here in a timely manner. So for those reasons, the procedural technicality of it, I am going to grant the request to set aside the order adopting the referee's recommendation and find that the objection was timely entered, which brings us to, so counsel, if you would, plaintiff's counsel, if you would prepare an order that grants that motion for my signature, I would appreciate that. And then that brings us to today, where there is the request for a de novo hearing. So I'll hear argument on whether or not we should have a de novo hearing, and then we'll set, if that's granted, we'll set a time in the future for the actual argument. And because I have not had a chance to review the referee's CD or the video of that yet. So we'll hear some argument on whether or not we should have a de novo hearing. So I'll allow plaintiff now to argue that motion. Go ahead, sir.
Thank you, Your Honor. As I was just mentioning, this hearing was originally scheduled for October 15th, the referee evidentiary hearing. And then suddenly, I believe my client got notice on September 8th that the hearing was now being moved up to September 15th. The notice for that hearings was actually prepared on September 9th. And I think that leaves her at a severe disadvantage. She did try to get officials from both schools as well as other witnesses to appear for that hearing. Of course, she is not an attorney. I understand that she didn't know how to subpoena these witnesses, but I must say, even if I had 6 days notice of a hearing, I think it would be very difficult for me to get witnesses subpoenaed for an evidentiary hearing on such short turnaround. So with that, I think immediately she was at a disadvantage for this hearing. And first of all, the referee did not hear, because of this, testimony from any personnel at the child's school, the prior school, or the current school. Yet these are the individuals who teach, evaluate, and observe this child daily. It's not just based on subjective opinions of the parties. And we believe that these witnesses would have central facts under several best interest factors, particularly B, H, and J. Without that testimony, the referee clearly lacks a complete evidentiary basis to assess the child's schooling needs and whether or not the current school versus the prior school, who is better equipped to accommodate the child. Not to mention, the referee didn't hear any testimony regarding other options as well, such as other schools, homeschooling, whatever else there could be. I think it's also important to note that this objection appeared, or the recommendation, Your Honor, appears to be more heavily focused on sanction driven regarding my client and her procedural deficiencies in going about this, rather than what's actually in the child's best interest. So we believe that the Michigan courts have recognized that this de novo process exists to ensure that the judge and the referee can make the ultimate decision on contested issues based on a complete record, and that the court uses the de novo hearing to receive additional evidence where the referee's record does not adequately address the child's best interest. And that's what we think is going on here. We don't believe that this is a minor issue. The school placement is significant. It affects the child's stability, daily routine, connections, access to academic supports, which I think is clearly controlling in this case, simply because this child does have an IEP. And this kind of decision of this magnitude should not rest on a partially complete record. We are not asking the court to rehear this matter. We're not asking the court to relitigate. We're just asking to supplement additional testimony. So that's
Guys, the judge just flipped the entire ruling and brought this case back to life. This is where the courtroom energy shifts and every word suddenly matters again.
so that this court can make a proper decision in the child's best interest. At the end of the day, Your Honor, I think the process here was procedurally deficient itself in the fact that there was such short notice for my client to gather these witnesses for this hearing. And we would just ask that this court either send this case back to the referee in order to conduct some supplemental testimony, or this court can hear that on a de novo hearing. But we would ask that this court allow my client to present that evidence and testimony.
Defense counsel?
Thank you, Your Honor. First, I rely on all of the arguments set forth in my response to plaintiff's objection. The fact of the matter is Ms. Rollins failed to properly prepare for what was a 3-hour evidentiary hearing. She can claim all she wants that she didn't have time to prepare, but my client had the same amount of time. She filed to my office 3 days before the evidentiary hearing a list of proposed exhibits and witnesses. She failed to call witnesses. She failed to and I will disclaim my colleague did handle the evidentiary hearing. So to my knowledge, she did not submit any evidence at the evidentiary hearing. She could have raised procedural issues at that time or timeliness issues, and that was not done. In fact, now she's retained counsel just days before the deadline. And as we just went over, had issues getting an objection in timely. And now she does want to relitigate this whole case. Her whole 60-some paragraph objection sets forth what evidence she will present, what witnesses she would like to call. All of that would have been available and was available to her at the evidentiary hearing. She filed an ex parte motion trying to change the child's school. It was denied. My client did the same thing to try to prevent the change of school. That was denied. And there were several hearings noticed. My office had to call the court numerous times to make sure we were prepared and that what was noticed was actually what was happening that day. She could have done the exact same thing and failed to do so. The fact that she was underprepared for, again, what was a 3-hour evidentiary hearing, it would be prejudicial to my client if this court allowed another full-blown evidentiary hearing. Pursuant to MCR 3.215 F2, this court does have discretion to limit witnesses and exhibits that were available to her at the time of the evidentiary hearing. Frankly, I don't think a de novo hearing should be granted at all in this case, but if one is, I would request that they are limited to new evidence available after the evidentiary hearing, which frankly will only be detrimental to her because the child is not doing well in his current school. I also do want to point out that she continues to violate this court's order despite the referee's recommendation admonishing her for saying, we are now going on 4 months of the child being in a choice of school of her choice only that only benefits her. The child, again, is doing extremely poorly, and for sake of arguing against my own argument of bringing up new evidence, this cannot continue to go on. We have a show cause motion pending, and I believe sanctions should be granted against her, and the child should immediately be replaced in Gaylord Community Schools.
May I have a brief response? Yes, thank you, Your Honor. So first of all, I would caution the court as to allowing counsel to provide facts that have not been proven or testify to regarding how the child is currently doing. I will say that I think it's even more concerning that neither one of these parties actually reside in this district anymore. I can't even sit here and say today that this child could even be allowed back into the Gaylord School District. My client has sold her home, and it's not just as simple as, well, it's in this child's best interest that we limit this witness testimony. This court's job is to determine what is actually in this child's best interest. And the only way they can do that is to get a full record to review. I would say that these witnesses weren't available on such short notice, and I do not think any witnesses should be limited. I don't think that my goal here is not to have cumulative testimony. It's not to put my client back on the stand to testify to what she already did, but it would be my intent to take a few hours to get the people in here, and maybe the court's opinion changes, maybe it doesn't. But I think by giving my client less than 7 days notice for this hearing did put her at a disadvantage. I do think that's a violation of her due process. And at the end of the day, we don't feel in any way, shape, or form that any of this is to serve the best interest of the child rather than just sanction my client.
May I respond, Your Honor?
No. How is it that your client, plaintiff's counsel, didn't have notice, didn't have preparation time when she didn't bring the issue of changing schools to the court's attention until the end of August? How is it that she would not have proper notice that a hearing would be required and that witnesses and school information would be necessary when she waited until August the 28th to even file a first motion regarding changing school systems beginning the next weekend or after the next weekend, after the Labor Day weekend? So
Yes,
how
sir.
is it that she did not have sufficient time to file a motion and gather the witnesses and evidence that she needed during the entire length of the summer preceding her motion?
And I think that's a fair question, Your Honor. I think that just lends questions to the timeline here. My understanding is that my client had discussed this with the opposing party, and it wasn't until the end of summer that he indicated he wasn't okay with this arrangement. That's my understanding. And at that point, was well underway of already. I mean, obviously, she had to take steps to get this child into this school ahead of that filing. It wasn't until it was clear that he wasn't actually agreeing to anything and that this was a legitimate problem and that she learned what the process was that she did file that motion. And from when I look at it, it was kind of a messy start to the case and the fact that there were several ex partes filed. The best procedure probably wasn't followed here, and hindsight is 2020. But nonetheless, I think that's still different. She filed the motion. I can't even say if she knew who the teachers were at the new school at the time that she filed that motion. But even then, in my experience with these school officials, they're not going to show up unless they do have a subpoena. And you get that advice from their counsel. So she filed this on the 28th, and then there was a hearing on the 15th. I still think there was no way for her to know when a hearing would actually be scheduled, especially since the original notice was for October 15th and then got pushed up a month. So that was just kind of unusual, I think, with the timing.
It was unusual because the court wanted to make a decision before the child was in school for any length of time, which is how that decision is supposed to be made. It's supposed to not jerk a child out of a school system and bounce it back and forth. And the court had no way of knowing which way the case was going to go. So we set it as early as possible so that we could make a decision that would not unfairly jerk the child around if a decision to the contrary was made. I think the court did everything in its power to make amends for the mess that the plaintiff created. We tried to have a hearing as quickly as possible so that neither side was prejudiced and the child was not clearly prejudiced by moving school districts. She's the one who made the unilateral decision to move the school districts without prior court intervention, which is something that just simply should not be done, period. She did it. She bears the consequences of that decision. And the consequence is there was a shorter timeline. That's not the court's fault, and it's not the defendant's fault. She had every time to gather the evidence during the summer. She didn't make a decision to go over to the Traverse City area or the Forest Schools area on August the 28th. She had that decision made many weeks in advance of that. So she's had plenty of time, in my view, to gather that evidence and to have those witnesses available ahead of time. The fact that she waited until the last minute to gather the evidence is nobody's fault but her own. So no, under the statute, I'm not going to give her the ability to call witnesses that she could have had previously. NCL 552.507 Subsection B, subsection 6 says that a de novo hearing includes a new decision based entirely on the record of previous hearing, including any documentation submitted there. And that's what we're going to do. I'm going to make it on the information that was available to the referee at that time. The court has the discretion under that statute to prohibit the party from presenting evidence that was not objected to determine the referee's finding conclusive as to any fact that was not objected to, and to prohibit the introduction of new evidence or use of new witnesses absent showing that the evidence was not available at the referee hearing. I believe that that evidence was available at the prior referee hearing for all the reasons I've stated on the record. So I will grant your request for a de novo review. I will make that de novo review based on the information previously provided to the referee, and I'll issue my written opinion as quickly as possible thereafter. Defense counsel, if you prepare that second order with that ruling, I appreciate it. Is there anything else that we need to do today, counsel?
I don't believe so, Your Honor.
Thank you very much. That's all then.
Thank you, Your Honor.
The judge dismantles her claim of short notice, insisting she had all summer to prepare properly. He frames the timeline as her own making, not a courtroom injustice. A new review is granted, but the door to fresh evidence is firmly locked shut. She gets another chance, but not another redo, only the record as it already stands. Make sure to like this video and subscribe to the channel, and we'll see you in the next video.